Hi everybody, how are you all doing? This is the first session that we are having, which is being conducted by me on behalf of Oliveboard in the new year. So, a very happy new year to all of you. And this is the first time I'll be doing a YouTube live. So, what I'm going to do is I'm going to check my phone here to see your comments. And my way of interacting with you will be through you putting in your comments. And good evening, Safa. Thank you so much for joining us. Um, so I'll keep checking in between. I would want this to be as interactive as possible. We are waiting for more of you to join in before we officially begin. But in the meanwhile, what I can tell you is that Olive Board has come up with really exciting and very comprehensive courses on judiciary. So if you are a judiciary aspirant or if you are thinking of becoming a judiciary aspirant and starting your preparation, then their courses will be fantastic for you. They have covered all the Hindi speaking states, and they also cover Delhi Judiciary Services, and you'll get all the material, live classes, study resources, everything else you can check out on their official website and see if the course is something that you would like to do. If you would like to enroll yourself, you can use the code on your screen, which is Sanya, Sanya, to avail 45% flat off. um so how are we doing? You can just let me know in the chat box, and this is how I'll be interacting with all of you. I believe we can officially begin with today's lecture. Today we are going to talk about Indian Evidence Act. A lot of you, if you're still in law school, you must not have started with your Indian Evidence Act in the first semester or the second semester also. The reason being that it is a procedural law. So, as we have discussed in earlier sessions, and if you're not aware of this, there is a difference between substantive law and procedural law. Indian Evidence Act is about the procedure. It's about what constitutes evidence and what does not constitute evidence, how to produce it, how to prove it, how to disprove it, what will be considered by the court to be admissible, what are admissions, confessions, how are they to be made, and so exactly how the rules are carried out in the courtroom practically, the procedure that has to be followed by all the courts, that is covered in Indian Evidence Act. And this becomes a very significant law, specifically if you are preparing for your LLM entrance, if you are preparing for your judiciary exams, because procedure is very important at a higher level in your legal profession, in your legal studies. So we're going to talk about that. um, what our agenda for today is. First of all, we are going to understand what do we mean by evidence. What does the term evidence signify? In layman's language, in plain language. And then we are going to talk about what is evidence law. So first we'll understand the meaning of evidence, just what it means in general English, and then we'll understand what is the law on this. Then we will discuss primary evidence and secondary evidence. And finally, we'll talk about what are facts. Now, if you have not studied Indian Evidence Act before, this is going to be a little complicated, but I'll try to simplify it for you as much as possible to give you a background on where the act came from, why it was enacted, who wrote it, who authored it. We're going to talk about that also, and the applicability and how to study the provisions. So, this is an introduction to the Indian Evidence Act. We have very limited time together, which is barely about an hour, and we cannot cover the entire act or everything that's important about this law in that 1 hour. So, what I'm going to do is I'm going to give you a brief introduction. We'll talk about some basic concepts, we'll discuss your queries, and then you will have to do the studying. Okay, so study the bare acts, study the case laws, study everything else, all the interpretations that you need to dive deep into this, to delve deep into this. I am not going to read out legal provisions. We're not going to just discuss what each word means. we will interact, we will see how it's practically applied, and we will see the significance and the scope of the act. Now, like I told you, I will tell you how this act came into being, into existence. So it came into existence in 1872. We were still being ruled by the British, and there was a very famous lawyer and a judge, Sir James Fitzjames Stephen. He actually authored the law on evidence. It was under the British era and through the Englishmen only that the law on evidence was codified. That means that universal application for the rules of evidence was implemented in the country for the first time across all castes, genders, race, sex. And what he had said this, and this quote is significant because if you, when you start reading the act and after you're done with it, you will see that what is the most important thing when it comes to producing evidence in a court of law, in a court of justice. And hardly in exceptional circumstances only, the spoken word is given importance, it's given relevance. So he had said this once, that the things which cannot be adequately represented by words are more important than those which can. So the things which are not exactly put in words, are not spoken, those things are more important. So the things that can be seen, the things that are written, are more important than the things that are said, the words that are spoken. Now, before we move on further in discussing what evidence means in layman's language, can you just tell me in the chat box if you have studied Indian Evidence Act, or if you have started with Indian Evidence Act in your law schools, if you are still a law student? You can just write yes or no in the chat box. So it's important for me to know that. I know Safa is still in law school, but I'm not sure. Okay, Safa has just started. Okay, great. Thank you. Thank you so much for interacting. So, you must have been, familiarized with what the Bear Act looks like, how many sections there are, and what is the layout of the Act, and what it talks about in general. So, it's a good thing that you have started with it. What does evidence mean in layman's language? If you just do a plain Google search, you'll see that it says the available body of facts or information indicating whether a belief or proposition is true or valid. So, the two keywords from this definition that you can take is are facts and information. We have to understand what do facts mean. We have to understand what does information mean and why is it significant. Evidence is derived from a Latin term called evidere, which means to ascertain the truth of something, to prove something, to understand if something is true or not, if it is right or wrong. So we often confuse the term evidence with proof. Proof is when a fact has already been proved, and evidence is the act of proving it. So the Indian Evidence Act uh, defines evidence in section 3, as we will discuss in the further slide. But before we do that, let's understand the basic scope of it and the layout. Layout is essentially what does it contain, how many sections are there, what are the different parts and chapters and things like that. So as I told you, Indian Evidence Act was written by Sir James Fitzjames Stephen, and it came into effect from 1st September 1872. Now, this date becomes very significant, especially if you're preparing for an entrance exam, because they ask you these questions in multiple choice questions in prelims of judiciary. To tell exactly when was the date when the act actually came into effect. And another reason why this date is important is it's the same date when the Contract Act also came into effect in our country. So 1st September 1872, the preamble of the act tells you. And if you've not attended the previous session that I conducted on CPC, then please do that, because in that we talk about the general structure of a bare act. So it starts with the preamble. Preamble gives you the reason why the act or the law was enacted in the first place. And that reason given in this particular act is to consolidate, to define, and to amend the law of evidence. So consolidation was required because in India, and up until then, there was no one uniform law that defined the rules of evidence, which means that what will be treated by court as evidence to prove or disprove a certain allegation that has been brought to the notice of the court. Nobody knew. Everybody applied their own customs, their rituals, their rights, their ideologies, their beliefs. So it was very subjective, which is not fair. So when we talk about justice, when we talk about fair trial, when we talk about being unbiased, there should not be any scope of being subjective. And before that, in Muslim law also, when we were governed by Muslims, at that point also there was no codification of the evidence law. But in Dharma Shastras, it has been mentioned that the king should look at all the facts and all the evidence in an unbiased manner before pronouncing a punishment or a judgment against the wrongdoer or the subject. So it has always been there, but it hasn't really been vocalized and also codified. So this act was enacted to codify these rules. Now, the first section, which is section 1, will tell you about the scope, the extent, and the applicability of the act. So you have to take into consideration the fact that at that point, it was applicable to whole of India except for state of Jammu and Kashmir. But after the J&K reorganization order for applicability and adaptation of central laws, which was passed in on 31st March 2020, the Indian Evidence Act is now applicable to the state of Jammu and Kashmir as well. So there has been an amendment to the scope and the extent and the applicability of this act, which is given to you in section 1, under section 1. And there are certain exceptions. So there are certain situations where the act does not apply, and we will talk about that in the following slide. Now, what is the layout of the Act? The Act contains 11 chapters. These 11 chapters are divided into three broad parts. There is one part that discusses relevancy of facts. There's another part that discusses proof, what constitutes proof. And there is part 3, which tells you how to produce and what is the effect of evidence that you produce in a courtroom. So there are these three broad parts, and every part is also subdivided into some legal provisions and sections. There are in total 167 sections of the Act, so it is not very voluminous, but it takes a lot of time to really understand what every section is trying to say. The words have been used very strategically, and there's a minimal word count for this Act, but it is very, very important to understand what each term means. And since we don't have that kind of time, and also I don't believe in that kind of teaching learning experience, so I'm not going to read out those sections to you, but I would tell you what sections are significant for our today's session, and you can after the session just read out those sections and see if they mean something to you, if they make any sense to you. Now, like I told you, there are certain exceptions to the applicability of the Indian Evidence Act, and the Act contains the rules of evidence that are to be followed in a courtroom, right? And a courtroom is a place where there is a presiding officer in the form of a judge or a magistrate, and there are certain definitions to be taken into consideration for that also, which we will discuss. But there are exceptions. In certain cases we do not apply the rules of evidence. That means the provisions of the act are not applicable to those circumstances. The first is court martial. So as we know, in armed forces, in navy, in air forces of our country, they have their own laws, they have their own way of administration of justice, and they have their own court martial where the laws of evidence, the rules of evidence in this particular act do not apply. Then another thing, which can be a bit confusing, But as you study further and as you start interlinking one provision with another, one bare act with another, you'll be able to make more sense of it. The evidence rules are not applicable to affidavits. Now, to understand that better, you'll have to read Order 19 of Civil Procedure Code of Civil Procedure, uh, because there are certain situations, and in civil cases especially, where the court has the power to say that instead of giving me a testimony right away, or instead of showing me some document, all you have to do is just file an affidavit by way and evidence by way of affidavit, which means that you have to give a sworn statement that whatever you're saying is true to the best of your knowledge, and that affidavit then gets cross examined later. So you'll understand that better once you know the stages of the case, and you also know how civil courts work and criminal courts work. But there are certain circumstances, and the courts have the power to say that I will accept affidavit, and on those affidavits, the rules of evidence or this particular act does not apply. Then arbitration. In arbitration proceedings, an arbitrator and arbitration proceedings are not considered to be judicial proceedings. And that is why the rules of evidence do not apply, and it is completely at the discretion of the arbitrator how they want to examine whatever documents are in front of them, or whatever facts are trying to be are being proved or disproved in front of them. Then in non-judicial proceedings, so if there's a special law, let's say if it's Consumer Protection Act, or it's NCLT, so there's Insolvency and Bankruptcy Code, there's a special law to that. So the law, that code, that statute itself defines how they will proceed with the case, what will be considered as evidence, and at what stage it has to be produced, and like what. So the rules of evidence in this particular act do not apply to the non-judicial proceedings also. So judicial proceedings are only those proceedings which are happening in a courtroom where the court has the power to legally take evidence on oath. And this also is something that you will understand better when you read different definitions that are being given in different statute, and we will discuss that later. First, let's understand what the law says about evidence. So, what is the meaning of evidence as per the Indian Evidence Act? In this particular act, Section 2 was repealed. Otherwise, generally, what happens in bare acts, in statutes, it's either Section 2 or Section 3 that will carry important definitions. And it's a very, very important clause, it's a very important provision. So, you have to study those definitions to understand what those terms mean throughout the law, throughout the act. And Section 3 in this particular act defines evidence, just like other interpretations and definitions are also given in Section 3. So the definition of court, the definition of documents, definition of oral evidence, direct evidence, and things like that, all of those things are given in Section 3. Definition of facts is also given in Section 3. So just to give you a basic idea what the law says about evidence. So law says that any statement which is mandated by court, or which is permitted by court, and is given on oath to the court, that statement is evidence. Any document which includes electronic records. Now, electronic records are, as we know, some recorded telephonic conversations, or let's say that there's a CD-ROM that has a lot of folders and files. So those are electronic records. Uh, Now the recording that I was talking about, there's a separate body of interpretations and the laws that are around that, and about the admissibility. One case is a very important case that I will discuss with you later. But that electronic record is also a document, and whatever documents can be produced before the court for the court's inspection also constitutes as evidence. Now you have to understand that for anything to be taken as evidence, to be admissible as evidence in a court of law, it should be specified and it should be explained properly that it is to prove or disprove a relevant fact or a fact in issue. That is also something that we will talk about later, but I want you to bear this in your mind right now, that everything should be relevant. Like we just discussed, part 1 is about relevancy of facts. So the act also goes on to explain what facts are relevant, what are not relevant, what facts have to be proved, how they are to be proved, and what is primary evidence, secondary evidence. Everything is being given in the act, and we'll discuss it today briefly. But the evidence that has to be given in a court of law or in a court of justice is towards proving or disproving a relevant fact or a fact in issue. So it can be statements, which means oral testimony that we talk about, and it can be document, which is the documentary evidence, which can be primary or secondary, something we will elaborate on. Now, are there any questions till now? You can just write your questions in the chat box. I'll keep looking back and forth, and I'll keep checking if there are any questions that I can address right now before moving further. I'll do that. If there are no questions right now and you want some questions to be addressed towards the end of the session also, you can put them in the chat box. And let's make it as interactive as possible. Let's discuss it. I don't want it to be a monologue, and I want you to really gain something valuable after today's session. So, if there is any question, don't worry about it being stupid or not important enough. Just put it in the chat box. Now, as I told you, to understand what court means, it's not just what we understand court to mean, we also have to go by the law. So section 3 talks about what is the definition of court also. So it includes all the judges and the magistrates and all persons except arbitrators legally authorized to take evidence. So arbitrators are not considered to be judges or magistrates. Now, to understand the definition of a judge, you can go through section 19 of IPC or section 2 subclause 8 of CPC. Now, judge is the presiding officer of a courtroom, and the judge is authorized to legally pronounce a judgment after taking into consideration all the evidence and all the documents and everything else that has been given to that judge, that the judge is legally obligated to and legally permitted to take on oath. And then considering those documents, those testimonies, and the arguments of both the parties, the judge has the power by law to pronounce a judgment. So, anybody who has that power by law is a judge. In criminal cases, we call him or her a magistrate. And it is only applicable to judicial proceedings, like we just discussed. So, it arbitration proceedings and special proceedings that are being conducted in special tribunals. Let's say a show cause hearing is happening before the trademark registry, or a petition or an application has been filed in National Company Law Tribunal. So that is not a judicial proceeding per se. An arbitration is not a judicial proceeding per se. A judicial proceeding in common terms is anything that happens in civil courts or criminal courts, the High Court, the District Court, Supreme Court. So that is a courtroom, and it's only when it's a courtroom that the rules of evidence apply. Now, you have to understand that evidence can also be classified into different categories, and these are very broad categories. They can be subclassified into other categories also. But whatever has to be given as evidence, like we just discussed, must be proving or disproving a fact. And what is a fact is something we'll discuss in the following slide, since it is the most significant topic for today's session. And we'll first understand why we need to understand what fact means. So there are these different kinds of evidence. Just to give you a brief overview, in every civil and criminal case, there are different stages that a case follows. So first the case will be filed, and after filing the case, a notice or the court summons will be issued to the party against whom the case has been filed. And after the summons have been issued, the defendant will be required to appear before the court, and once they appear before the court, they will be required to give a defense, like why should the court not proceed against them. And after they do that, after they file their defense, their written statement, you go on to the judge or the magistrate coming down to settlement of issues or the pronouncing of charges. In civil cases, it's issues. In criminal cases, it's charges. Now, issues and charges are basically the most important questions, the most important controversial things that are to be decided by the judge or the magistrate at the end of the entire proceeding. So, those questions, those controversial facts, those controverted bones of contentions are settlement of issues or the framing of charges, framing of issues or framing of charges. After the issues have been framed or the charges have been framed, you go on to producing the evidence, and that is when the rules of evidence become of significant importance, because at that stage you have to decide what is it that you want to give to the court to corroborate whatever position you are taking or whatever allegation you have made or however you like to defend yourself, because in a court of law the judge will never ever take you on the face value. So just because you've said something, it doesn't mean that it's true, and there are various rules of evidence that have to be followed to prove what you're trying to say is true. And that is when the Indian Evidence Act comes into play. And after the evidence has been adduced by both the parties, you go on to the final arguments, and after which the judgment is pronounced. So, those are the broad stages that a case follows after it has been filed. Now, that evidence that you can provide at the stage of evidence can be oral, and by oral, in the most simple terms, we mean witness testimony. And who constitutes a credible witness, who can be a credible witness, what can the witness say or can't say, and what are the rules to be followed in examination of the witness and the cross examination. Again, everything has been given in the act, but that is not something we'll discuss in detail today. For now, all you need to understand is that section 60 talks about oral evidence, and oral evidence is essentially a witness testimony. One thing that you have to take very much care of at this point is that oral testimony can only be direct, which means that I can give a testimonial or I can go and give a statement under oath before a judge or a magistrate only if I have seen something happening, or I have heard something happening, or I have experienced something with my five senses. And that is only what I can tell the court with complete accuracy. However, I remember it with complete certainty that it happened the way I believe it to have happened. It can only be direct evidence. Of course, there are exceptions to this, and we will discuss one of the exceptions today later, but general rule is that oral testimony should be direct. So, for example, if A has murdered B and C has seen the murder happening, then C can go and be a witness and give an oral evidence, oral testimony of what he saw at the scene of crime. And that can be the oral evidence. For example, after that, C goes back home and tells D what happened. Then D cannot be like, okay, I'll go to the court and I'll tell the court what C had seen. No, C is the only one who can produce oral evidence, not D. Then we move on to documentary evidence. Now, Section 3 of the Act also explains what documents mean. Broadly speaking, document can be either public or private, and document can be given through either primary evidence or secondary evidence. and we'll discuss that briefly just now. So anything that's written or lithographed or written on a metal or is a map or a caricature, it can be considered as a document as has been given under section 3 of the act. Now that document can be available to public. So let's say it's a document that has been in the tehsil office. It's a document that is, let's say, your Aadhaar card details, or any other property related document that you may have that is with the government also, that's available in public domain or is available with government authorities, then it's a public document. Every other kind of document is a private document. So a contract that you sign as a private party with another private person is a private document. A will, until and unless it is executed and then a court decree is passed when it comes to probate of the will, that will is a private document. So section 3 you'll read to understand in depth what documents are, and what is public document and private document is something that you can understand by reading section 74 and section 75 of the act. Section 62 talks about primary evidence. So the document, if I'm giving an original of the document, then it will be a primary evidence. So just to give you a brief idea and a broad viewpoint on this. So for example, if I am the owner of my property and I have the original sale deed, or I have the original RC, which is the registration certificate for my car, to prove that I'm the owner of the car, then that will become the primary evidence. If for some reason I cannot produce original documents, let's say it was a counterpart of a document. Counterpart is, for example, I entered into a contract with, say, Safa. I entered into a contract with Safa, and Safa is in the US, and I am here in Gurgaon. And we had a digital contract, or we got our respective contracts notarized in our respective districts in our respective countries. Then I will be getting a counterpart of the same agreement. So both those agreements can be considered to be the primary evidence, since both of them are being signed and both of them belong to the parties that are to the contract. And that can be considered as a primary evidence. But for example, let's say that I and Safa enter into a contract, and then there is, say, Mahima. Mahima is not a party to the contract, but she has somehow acquired the counterpart of the document of the contract that was between me and Safa. Then Mahima, if she provides the counterpart of that document without being a party to the contract before the court, then that will be considered as secondary evidence. Now, as broadly speaking, I guess you must have understood by now that primary evidence has more reliability and more significance when it comes to the judge or the magistrate actually placing reliance on those documents to understand if a fact is to be proved or disproved. And secondary evidence is to be provided when primary evidence cannot be provided, and it has lesser reliability and will need other corroborative factors, other circumstantial proofs to prove that secondary evidence is actually admissible or accepted by the court of law to be considered into the overall case while deciding the judgment. Now, we are going to talk about the most important topic for today, which is discussing what exactly are facts. Facts that have to be proved or disproved by providing evidence to the court of law. What do these facts mean? So we'll talk about that. Before that, if there are any questions, you can just put in the chat box. If there are no questions, can you just write no? So Safa, you can let me know. Till now, if anything you would like me to repeat or to explain. Okay, so let's move on. What are facts? Now, as per Section 3 of the Act, fact means and includes anything, state of things, or relation of things capable of being perceived by the senses, any mental condition of which any person is conscious. So, broadly speaking, we have physical and psychological meanings of facts. So anything that can be perceived by our senses, our five senses, anything that I can see, for example, I can see a television set right in front of me right now, then it is a fact. If I am feeling very excited and enthusiastic for something, then it is a psychological fact, but it is a fact. It's a mental condition of which I am conscious. So this is the broad definition that has been given in the Act. Now, those facts have to be proved or disproved in order for a case to actually reach its final conclusion, which will be pronouncement of the judgment. Now, to explain what facts in issue are and what relevant facts are, let's just take an example, okay? For example, A shot B dead with a gun. So the prosecution, once the case is registered against A and the state moves against A, so the state will be prosecution and A will be the accused. And as we know, the general rule is innocent until proven guilty. So you have to prove A guilty. So the fact that A shot B, B died because A shot B, or also the fact that maybe the B was provoking A, or maybe there was a disrupted or a conflict between A and B, so their relationship with each other. These three things, they are facts in issue. So, like I just told you that there's a settlement of issue or settlement of charges in civil and criminal cases, and these issues or charges are basically what are being asserted by one party to a case and what are being denied by the other party to the case. So, if the prosecution in this case will say that A has murdered B, then A, the defense the defense counsel of A, which is the accused person, the defense counsel will say that no, A did not murder B. Okay, so this fact that whether or not A murdered B will become a fact in issue. It will become a controversy that has to be resolved by the court of law. And what is relevant to prove that A actually murdered B and to disprove that A actually murdered B will also become important, and those facts will be called relevant facts. Okay, this is just a very, very basic, simple layman terms example to you. Now, A will try to say that maybe it was private defense, or maybe A was not in the right mental health at that point, or maybe B had actually provoked A, so that's why A had to do it because he was provoked by B, or maybe somebody else told A to do it, so A did it. Okay, so those things, the defenses that A will use will have to be disproved by the prosecution. So the onus means the burden to discharge an issue, the burden to actually prove something is by the one who's asserting something. Okay, so if the prosecution is saying that A has killed B, then the prosecution will have to prove that A has killed B, and A will not have to prove anything. A will just have to give his defense without admitting anything, without proving anything. And the proof the standard of proof in criminal cases is also extremely high because the stakes are so high. So the proof also has to be beyond a reasonable doubt. So in that case, what are relevant facts in this situation? The conduct of A, what happened a day before, what happened a day later, that becomes relevant if it's adding to the chain of events. So we have to deconstruct and reconstruct what must have happened at the crime scene. If C saw A actually shoot at B, then C will become a witness and will provide a direct evidence, and prosecution will be leading evidence. And the fact that C saw A shoot B becomes very relevant. If A and B had a conflicting relationship, that fact also becomes relevant. If, let's say, a day before the incident actually took place, the crime actually happened, a day before that, A went to a person and bought a gun. Let's say A bought a gun from Y, then this fact also becomes relevant. Even if it's not happening at the same time of the incident, it's not being, see the that Y has not actually seen A kill B with that gun, but the fact that Y actually sold the gun to A, that becomes a relevant fact. And if after the murder A tried to hide the gun, then that also becomes a relevant fact. So that tells the conduct. Now, to understand what are relevant facts, of course, Section 3 has given a definition, but relevancy of facts can be understood better if you read Section 6, Section 7, Section 8, Section 9, Section 10, 14, and 15 of the Indian Evidence Act to understand what exactly are relevant facts and what are not relevant facts. Now if I say, let's if I just say that A was married to X, then is that a relevant fact? If X has seen um, A murder B, or if she was at the crime scene, or if she had a relationship with the victim, then yes, it can be a relevant fact. But if she has nothing to do with the crime or the victim, or had no knowledge or anything whatsoever, then it is not a relevant fact. So only relevant facts are to be proved or disproved by providing evidence, and not every fact is a relevant fact. Only relevant facts can be admissible as evidence by a court of law, but and all the admissible facts, all the facts that are admitted by court as an evidence, they are all supposed to be relevant facts. Okay, so now we will talk about a very important doctrine, which is a doctrine of res gestae. It has been condensed in section 6 of the act, and although the term res gestae has not been used anywhere, but it's a very significant doctrine, especially when it comes to criminal cases. Now what doctrine of res gestae says essentially is that if a fact is a part of the same transaction, and it is not a fact in issue or even directly a relevant fact, it still becomes relevant because it's so closely enmeshed with the transaction. And when we talk about transaction here, we mean the main point of controversy, the main event that has led the parties to actually go to the court. So, for example, if I say that, let's take the same example, A shot B and B was murdered. So, if the prosecution is alleging, then the entire crime scene is a transaction, is one transaction that's happening. A is buying the gun and then shooting B with the gun, and then B dying as a result of it. It's a transaction. Now, if I were to say, let's say that, like I just told you, C became the eyewitness and said that I saw A shoot at B. and which resulted in B's death. So that is also the same transaction. If, for example, before dying, right before dying, or as an immediate reaction to the gunshot that B received, before dying, B called the police or B shouted and yelled out A's name, then that fact also becomes important as a part of res geste, because it is the same transaction. It is circumstantial or indirect, so this is not something that B will be able to tell court, but the eyewitness will be able to tell court. So even though the eyewitness has not directly said it or directly done it, but the eyewitness has seen it, and this is a circumstance that had happened at that point. So if the eyewitness tells the judge or the magistrate in the court of law that I heard the victim yell out the accused person's name and call police or cry out in pain or abuse the victim at that point, then that becomes relevant, even though uh, B is not there to tell the court that I had actually done this or not. So same parties should be involved in this particular scenario for doctrine of res geste to apply. And hearsay, so this is an exception to the hearsay rule. I'm sure most of you must have heard this term. What is hearsay? Hearsay is basically just Chinese whispers. Okay, so I said something to you, you said something to somebody else, and that somebody else said something to another person who went to court and gave in a statement regarding that. Then that becomes hearsay. It's really, it cannot be proved who said what and what is the accuracy or the veracity of the statement. And since you have not seen it with your own eyes or heard it with your own ears, or that particular event is not something that was experienced by you through your five senses, you cannot testify to the fact that this actually happened. You only know to the extent of what you heard, and that also can be distorted by your own interpretation and memory and imagination. So, hearsay evidence is not permissible, it's not acceptable in a court of law except in certain circumstances, and doctrine of res geste is one such exception. So there was a very famous case. It's a landmark case, Vijay Vardhan. Vijay Vardhan versus State of Madhya Pradesh, I guess. But Vijay Vardhan was the name of the one of the parties. And in that, what had happened was the Supreme Court actually explained what is doctrine of res geste and said that it should be a part of the same transaction in the sense that it should be contemporaneous. It should be happening simultaneously as that event happened. It should be a reaction to it, an incident which is indicative of that particular event happening. So in this case, what had happened was Vijay Vardhan had just gone to a bus with flammables and had set the whole bus on fire, and there were a lot of dead people. And then after a lot of days, the magistrate recorded the statement of one of the victims, and it had to be decided by the court of law whether or not this statement could be a part of doctrine of res geste, and it was considered not to be a part of doctrine of res geste because it did not happen at the time of the event. It happened days later. So when there's a lot of gap between the incident and between the transaction, between the interaction or the conversation, then there are chances of fabrication. There's a chance of it not being as reliable as it should be for a fact to be proved or disproved beyond a reasonable doubt. So that does not become a part of res geste. But another case I'll tell you. I can't recall the name right now, but there was a very famous case, and this can be found in the Bear Act also when you study Section 6. Um, so the husband actually killed the wife, and before the wife died, she had called the police, and it had to be proved that the husband had actually done that with intention, with mens rea. So as you must have studied in IPC, that mens rea is very important for the offense to have actually been committed by the accused. So there's actus reus and there's mens rea. Mens rea tells the condition of the mind, the actual intention of doing something wrong and committing the crime or the offense. So if the mens rea is proved, it becomes murder. If the mens rea is not proved, it becomes culpable homicide not amounting to murder, which is a lesser punishment. So in this case, murder had to be proved. And when the police actually matched the time of the call, the distress call that they received, and what had happened in the house, when they tried to match and create a chain of events which should not be broken in the doctrine of res gestae, it was finally agreed, and it was held by the court that the phone call is a relevant fact. And the fact that she called right before she died, it shows that she knew she was going to get killed by her husband, which means the husband had the mens rea to kill her, and that's how it was proved. So the surrounding circumstances have to be taken into consideration to really understand doctrine of res gestae, which forms an exception to the principle that hearsay evidence is not admissible. Another exception to hearsay is dying declaration. That is also a very interesting concept in Indian Evidence Act, but that is for another day, so we will not discuss that right now. So that was all about, a general idea to give you about facts, about what are relevant facts, what are facts in issue, how they have to be proved, what evidence can be provided, primary evidence, secondary evidence, oral evidence, direct evidence, indirect evidence, circumstantial evidence. If you also want to understand a little bit more about circumstantial evidence, you can read more about it in the Panchsheel test guidelines that were given by the Supreme Court in Sharad Birdi case. So just it was a landmark judgment, and it gave five guidelines that where the magistrate actually explained. No, sorry, the Supreme Court actually explained what are the guidelines to be followed for a fact to be considered relevant in terms of circumstantial evidence. So understand that to understand that, you have to read that judgment. Now, evidence once proved becomes proof. So there's a marked difference between evidence and proof. Now we will just see the questions that you've put in the chat box. Let me read those out. So Safa has asked, when there is mere chance of reliability for secondary evidence, then why it is considered as an evidence in the court of law? Because Safa, there are a lot of circumstances and situations where it is nearly impossible to provide primary evidence, and there are certain documents which are presumed to be true by the court. For example, if you don't have an original of a property document and you get it from the tehsil, then the tehsil forms a part of the government and they have preserved the documents, so they will be giving you a true copy of the document. They will not be giving you the original document, and that true copy of the document is also considered to be reliable by the court. And then there are some certified copies of the judgments. If you can't get the original copy, or for whatever reason, if you cannot produce the original of the document, then you have to attest it yourself or get a true copy, or when it comes to judgments, you have to get certified copies, and those then will be decided by the judge whether or not they can be relied upon or not. The reliability factor is low, but it is there, so that if for some reason, there is no direct evidence, let's say, in the criminal case that we just discussed, let's say there was no eyewitness to the murder that happened. So what is the route for the prosecution to, prove what had happened at the crime scene at all, instead of just relying on the circumstantial evidence? Although the circumstantial evidence has to follow strict guidelines, and it has to take a lot more corroboration to actually justify it to the judge or the magistrate that what you're saying has actually happened. But there should be a way to provide evidence that cannot be direct, that cannot be primary. So that is why there's a provision for circumstantial evidence, indirect evidence, and also secondary evidence. I hope that clarifies your doubt. um The next question is, can someone be convicted on just circumstantial evidence? So there are a lot of cases. I can't recall exact names right now, but there are a lot of times where, like I just explained, there is no direct evidence, and there are some provisions in the Indian Evidence Act also where, the court may presume something and the court shall presume something. Section 4 explains it. So when the court has the discretion to presume that it had happened, the court can do that, and that is why, there are some provisions with may presume. And when there are some provisions that say shall presume, the court is mandated to presume that it had happened. For example, in rape cases, if you read section 114A of the Indian Evidence Act, you'll see that the court shall presume, if sexual intercourse has been proved, that yes, they actually had sexual intercourse, and if the woman, the victim, is saying that she did not give her consent, then the court has to presume that there was no consent until and unless it is disproved by the defendant or the accused. So there's a reversal of burden of proof. When you read judgments, when you also, if you've interned somewhere, when you prepare case files and read case files, you must have seen there are, when it comes to framing of issues and framing of charges, there's, in brackets it's written OPP or OPD. OPP means onus of proof on the prosecution, OPD means onus of proof on the defendant. So onus means the burden. So if you have the onus, then you have to prove that beyond a reasonable doubt. And in general cases, the accused does not have to prove anything, the prosecution has to prove things. But there's a reversal of burden of proof when it comes to rape cases, when it comes to sexual harassment cases, when it comes to dowry death cases. So even if there is no direct evidence, even if there is no primary witness or oral evidence or a reliable testimony, the circumstantial evidence, the indirect evidence, the secondary evidence can be relied upon, and the judge is to presume that it had actually happened until and unless the accused proves otherwise. Is that clear? So I hope that's clear, Safa. Thank you for asking the questions. They actually enriched the entire session and what I was trying to explain. Are there any other questions? You can just write in the chat box. So before we officially close, okay, great. So thank you everybody for being here. Once again, a very, very happy new year. If you're a judiciary aspirant, you have to look at the minute details also when you're preparing for your prelims. Try to also prepare for your mains at the same time, especially when it comes to subjects that are common to both. And try to practice how you're writing the answers, and read more case laws to understand how that particular provision has been interpreted and what are the connecting provisions, what are the linked provisions. So take that into consideration. Abhi UP judiciary notification is due this year, so we are expecting for that to be out soon. And you can just go to Oliveboard Judiciary to check all the notifications and all the updates. And there are a lot of free classes. Tomorrow we have another free class at 6 p.m. again, where we are going to talk about important case laws, landmark case laws, interesting case laws of 2021 that you should know about. And we will discuss them one by one tomorrow and see how many we can. And I will try to provide a resource for you to check out more important judgments, and also the judgments that you should look out for this year, which are pending. So we have another question by Safa. Safa asks, when eyewitness involved in both direct or circumstantial, then what is the difference between the two? So Safa, like I said, that eyewitness is somebody who has seen something with his or her own eyes. Okay. So if I see A shooting at B, which led to B's murder, then I am an eyewitness. But if, for example, I right after the the incident, the crime that has taken place, I call up my best friend and I tell her what I just saw. And I'm running to the police station to inform the police. And something happens to me in between. Either the accused catches up to me and kills me, or I meet with an accident and I'm not able to talk. Then the fact that I called my best friend and told her what I saw, since I am incapable of testifying in court, can be considered to be a relevant fact, and that is where circumstantial evidence comes into play. An eyewitness can only be the witness that has actually seen something happening, hear something happening. And that's why this is a very common defense. They are not able to, the prosecution is not always able to produce eyewitnesses, so they bring other people who can corroborate with the chain of events that the prosecution has come up with. So in a court of law, there are these different stories that are being told. The prosecution will tell one story and the accused will tell one story, right? And the judge has to decide, the magistrate has to decide which story is true or which story can be proved. And the chain of events are to be reconstructed by both the parties. Whoever knows the truth, whoever wants to prove something, they have to create a chain of events, that this happened first, then this happened, then this happened, and that's why I can infer. So there is this inference that this must have happened, because the prosecution, the lawyer was not there at the scene of crime, right? And a lot of the times the victim is also unable to really do anything about it. So they are not there at that point, and the accused will never say that, okay, what, I'll tell you the truth or whatever. It depends on accepting circumstances. But in that situation, you have to rely on circumstances, and you have to also ensure that the chain of events is not broken. So when you are talking about exceptions to hearsay, you have to take rest geste into consideration, you have to take time declaration into consideration, and you have to prove why this is a relevant fact and why this should be taken as evidence by the court of law. And then the court decides whether or not it can be admissible, whether or not it can be considered or relied upon while pronouncing the judgment. So it is largely about different facts and circumstances, and that's why circumstantial evidence also becomes important. So I hope that clarifies some doubts for you. Thank you so much for being so interactive, and thank you everybody for joining us today. Now I will just conclude the session, and if there are any further questions, you can always reach out to me at Law Chakra by Sanya on Instagram or LinkedIn, wherever you feel comfortable. You can reach out to me and you can ask me your questions. So have a great evening. Thank you for being here. Keep the learning spirit up, and I hope to see you tomorrow again. Bye.